Supreme Court in the matter of JOTHIRAGAWAN versus the state represented by the Inspector of Police allowed the appeal and said that having heard both the sides in the case, we have absolutely no doubt in our mind that the criminal proceedings initiated against the present appellant are nothing but an abuse of the process of the court. This is precisely a case where High Court should have interfered in exercise of inherent and extraordinary powers under Section 482 of CRPC. These proceedings cannot go on. Hence, we direct that the proceedings initiated at the instance of complainant, which are presently going on before the Sessions Judge, Erode in SC number 49 of 2022, be hereby quashed. On a reading of the statements made by the victim before the police, both the first information statement and that recorded later on, court said, we are not convinced that the sexual relationship admitted by both the parties was without the consent of the victim. That they were closely related in and were in a relationship is admitted by the victim. The allegation is also of threat and coercion against the victim to have sexual intercourse with the accused, which, even as per the victim's statement, was repeated thrice in the same manner when she willingly accompanied the accused to hotel room. Victim had also categorically stated that after the first incident and the second she was mentally upset, but that did not caution her from again accompanying the accused to hotel rooms. It is also categoric statement of the victim that after both instances victim was mentally upset, but did not prevent her from still going again and again to the very same hotel at the request of the accused a third time. The story was repeated of the talk of marriage having been kept aside till the sexual intercourse had been carried out again forcefully. There is also an allegation of threat and coercion. Before that, they had physical relationship. It is victim's case that after three incidents, complainant refused to pick up telephone, and when victim eventually could contact him, he refused to solemnize their relationship by a valid marriage. Court said that we have already found out there is no promise of marriage to coerce consent from the victim for intercourse. As forthcoming from the statements made by victim, promise, if any, was after the first physical intercourse, and even later allegation was forceful intercourse without any consent. In all three instances, it was the allegation that intercourse was on threat and coercion, where there was no consent spoken of by the victim, in which case there cannot be any inducement found on a promise held out. The allegation of forceful intercourse on threat and coercion is also not believable given the relationship admitted between the parties and the willing and repeated excursion to hotel rooms. An application made under Section 482 of the Criminal Procedure Code was rejected by High Court of Judicature at Madras, which was impugned herein.